Good afternoon, Judge Unterhalter.
Good afternoon, Chief Justice.
How are you this afternoon?
I'm very well, and how are you?
All right. Have you been waiting for a long time?
Yes, nothing like anticipation.
Yeah.
Chief Justice, I wonder if I might request before the proceedings begin, if I might make a very brief statement to the JSE.
Well, we haven't done that with anybody before, and I wasn't aware you were going to make such a request, and I have no idea what the statement will be about. That is the problem.
Well, Chief Justice, as I think all the commissioners know, there's been a complaint that has been made against me, and I want to make a very brief statement concerning that matter.
Well, if it's the one that is the matter that is with the JCC?
It is indeed.
Yes, I think there's a committee that has looked at the matter. I think that during the interview, you will get a chance to deal with it because they are going to raise it. I think you can deal with it when they raise it.
Well, I'll make my statement then. It's going to be raised in the course of the interview.
Yeah, well, they'll raise it with you and give you a chance to deal with it.
Well, then I'm ready to proceed.
Yes. I will ask you questions, and as you know, because you have been to this body quite a few times, other commissioners will ask you questions, but the questions we will ask you are aimed at us establishing how you fare when we look at the selection criteria that this body has adopted for the selection of judges. All of us are committed to treating all candidates with respect and courtesy. That doesn't mean that we won't be robust if we need to be, but you must just know that nobody has any intention in this room of humiliating you or any candidate. I think you are appearing before this body when I'm chairing maybe for the third time?
I think that's correct, yes.
Yeah, you may have appeared on other occasions when I wasn't there, but this is not new territory for you.
No, it isn't.
Yes. Okay, thank you very much. So let me start by thanking you for availing yourself for consideration for one of the positions in the Supreme Court of Appeal. We appreciate that you have availed yourself. You hold 4 degrees, BA from Cambridge, LLB from Wits, BCL from Oxford, MA and MA from Cambridge. Is that correct?
Yes, that's correct.
Yes. Before you were appointed as a judge, you practiced as an advocate for around 30 years, am I correct?
I think 27.
27.
Justice, yes.
Yes, yes. And during that time, you appeared in various courts in this country, including the Supreme Court of Appeal and the Constitutional Court, and of course, you appeared in the High Court, in various divisions of the High Court.
Yes, that's correct, quite frequently.
The last time you appeared before this body, I think, if I'm not mistaken, I may have counted the reported judgments that you had written. Were they in the region of 300, or was that cases in which you had appeared as an advocate?
There are many cases. I must say I haven't done the tally, but there are a lot.
Yeah. And you have written numerous articles that have been published, and you have contributed to some books as well, law books.
Yes, Chief Justice. Throughout my time at the bar, I also taught and held positions at universities, and as part of my academic work, I published various academic articles.
Yes. What was the year in which you were appointed to the High Court again?
2018, as I recall.
That would make it, what, 7 years as a judge?
No, not quite so much. It's
6.
5 years and 10
Some months. Oh, okay. During part of that period, you have acted in the SCA. How many stints have you done in the SCA?
Yes, Chief Justice, I must tell you that I've somewhat underestimated my acting stints on my application form because I didn't account for the second half of 2021. But if one includes those, which were 2 terms that I, in addition, spent in the SCA, my tally is, I think, 9 terms in the SCA.
9 terms. That would make it 2 years and a term.
I think that's correct, yes.
Yeah, that's quite some time.
It is, yes. And then I had 2 terms, as I think you will know, in the Constitutional Court.
Yes. How many terms did you do at the Constitutional Court? 2?
2 terms.
Yes. And you have obviously enjoyed yourself in the Supreme Court of Appeal, otherwise you would not be making yourself available.
Yes, absolutely, Chief Justice. It's a court which I have found to have both very interesting cases that come there. There's been a very collegial atmosphere within the court, which is very productive and very helpful. I've learned a great deal from those who are on the court, and it's a court I've enjoyed very much contributing to.
Yes. And I know from the previous interviews that many of the cases that you did were constitutional law cases, and you appeared in the High Courts about them and in the Constitutional Court.
When I was an advocate, or
yeah, when you were an advocate.
Yes, indeed. Constitutional law was one of the areas I practiced quite substantially.
Yes. Candidates that we have interviewed from yesterday, who are High Court judges, when I asked them about what exposure they have had to dealing with cases in the High Court where they are called upon to determine whether legislation is constitutionally invalid, have indicated basically that it's very difficult to get such cases in the High Courts. Many of them had not dealt with one, some of them having been judges for more than 10 years. Since you joined the High Court, have you found that it's not easy to find such cases yourself, or you have a different experience?
No, Chief Justice, they are relatively rare, but I have had numbers of cases in the appellate courts which have raised questions of constitutional validity in respect of legislation, and I'd be happy to explain more about those if that would be helpful.
Yes. And obviously, as counsel, if you appeared in the High Court or Constitutional Court with such cases, you would have been exposed to how the court is supposed to deal with a case such as that. So one, you confirm that you have had such cases both as counsel and as a judge?
Yes, I do confirm that. Many cases as a counsel and a number of cases as a judge.
Yes. And do you want to share with the commissioners a question I've been asking every candidate? how a judge is supposed to go about the business of determining whether legislation is inconsistent with the Constitution, so that they decide whether it should be declared invalid?
Yes, I'd happily do so.
Yes.
So the first step in the reasoning is to examine the statutory measure which is sought to be impugned. And that's an interpretive exercise, because one of the constitutional imperatives is to interpret the provision in such a way as to bring it into conformity with the Constitution if such an interpretation is supportable. So we don't assume that statutory provisions are unconstitutional unless we can find in the first place that there is no reasonable reading of the provision that would allow us to say that there isn't a potential violation of the Constitution. If one comes up with an interpretation that simply shows that there is a problematic feature to the statutory provision, one then has to, of course, examine what is the nature of the right that is being invoked under the Bill of Rights, if that's the nature of the challenge, which it usually is. And one has to understand precisely what does that right have to say, and what is its content that might bring about a conflict between the statute properly interpreted and the provision in the Constitution that the statute is said to offend. If one finds, after interpreting the relevant provision of the Constitution and the relevant provision of the statute, that there is a violation, then the question would turn to the issue of limitation if the state that is seeking to defend the constitutional challenge has raised limitation, and that's partly a question of law and partly a question of fact. It depends what has been raised in respect of limitation, and one would then have to consider the matter. And if one finds that there isn't justification of the invalidity that is established, then there's a question of remedy. So those are the four essential steps relevant to a challenge of this kind.
Yes, thank you. There are two types of discretion in law. Do you want to talk to the commissioners about what types of discretion one finds in law, and what differences there are between them, and what the legal significance is of their differences? Absolutely. For purposes of litigation?
Yes, well, there are two essential kinds of discretion that have been recognized, at least in the context of the question you've posed to me. The first is what is called discretion in the true sense. And a discretion in the true sense is a discretion which empowers the High Court to make a decision in respect of a number of possible options, each one of which is permissible. If the High Court decides upon a permissible option available to it, then unless the court has failed to exercise that discretion in a judicial fashion, and I'll come back to what that means, then it's not open to an appeal court to say, well, I would have preferred a different option, because as long as it's a permissible option, it is then part of a discretion in the true sense, and hence the standard of review is a very rigorous one in respect of appellate interference with a decision of that kind. That is to be contrasted with a discretion which is called a discretion in the loose sense. And a discretion in the loose sense is one where there may be a number of factors that are considered, but ultimately they are considered for the purposes of reaching a decision, not simply one of a number of permissible decisions. And under that second kind of discretion, an appellate court can interfere on the grounds of correctness, whereas in respect of the discretion in the true sense, correctness isn't the standard. The standard is whether it has been judicially exercised, and that is a capacious concept which means a number of things. Has largely there been a proper appreciation of the nature of the power enjoyed by the court, and has it been exercised upon the correct facts? And that, at least conceptually, is the distinction between these two. I think part of the confusion comes about because these terms, a discretion in the true sense and a discretion in the loose sense, are perhaps not the most apt ways of describing this, but that is how our law has come to describe them, and it's a bit late, I think, to change that terminology.
Thank you. I will now allow the Deputy President of the SA to put questions to you.
Yes.
Thank you, Chief Justice, and good afternoon, Judge Unterhalter.
Good afternoon, Deputy President.
When you were being questioned by the Chief Justice, you said that you have served as an acting judge of appeal in the SCA for 9 terms.
That's correct.
And is it so that you will be, in fact, your acting stint ends at the end of November this year?
That is correct. If we count that in, it would be 10 terms.
The judiciary plays a crucial role in giving meaning to the letter and spirit of the Constitution and the rights entrenched in the Constitution, and therefore contributes to the entrenchment of democracy in the country. Do you want to perhaps comment on that statement?
Yes, I would like to. Our Constitution came into being perhaps at a time of greater optimism in our national life. But I think that the Constitution still remains the absolutely foundational document which binds us together. And it is central to the purpose and point of courts of law is to allow that Constitution to flourish. Now, how that is to happen, of course, is a process of which cases come and how one can allow the Constitution to live. Unlike certain other appellate judges in other jurisdictions, it is a living document, and so is applied in different circumstances and in different times. But if I may say, Deputy President, that one of the difficulties is that saying those things is easy. Exactly how to do so is often much more difficult because it's a question of making concrete in actual cases how the Constitution should move us forward. And I'd be happy to answer questions as to how that arises in concrete cases. But one of the areas which is obviously one of the key provinces of the courts is the common law, because that's judge-made law. And how the Constitution should work in relation to the common law is a very fundamental part of what we should be doing.
Yes. And what would you say has been your notable contribution to the development of the South African law or jurisprudence and the continuing democratic project? Just briefly.
Yes. Well, I've listed some of the more important cases that I attach significance to, and I'm certainly not going to go through them because I'm sure this body has looked at what they think would be relevant in that regard. But if I could just very briefly touch on a couple of cases, just illustratively of the more general point that I have made. In respect of the Ndoro case, which concerned the South African Football Union, the question is, when can a private body be understood to be conducting or acting as a public body which is subject to the kinds of disciplines that exist in our administrative law? And I've sought to formulate a test which gathers together our jurisprudence on this subject. And among the tests is to recognize that the dividing line between public and private is one which needs to be carefully navigated. But of course, the consequence of drawing that line means that there isn't a sense in which private bodies which exercise significant coercive power in an exclusive and regulatory fashion can avoid the kinds of disciplines that exist in our public law. So that's just one example of the reach of public law into certain private domains which some courts have previously considered to simply be a matter of contract and not a matter of public discipline. That's just one illustration. I don't want to take too much time. I can give you other examples if they would be useful.
Thank you, fair enough. And wise in practice, you had a thriving and diversified practice with administrative and constitutional law being the two areas of the law in which you excelled. Would you accept that statement?
That is true, but over what was a long career at the bar, I was fortunate enough to be exposed to quite a number of areas of the law, of which I would say commercial law, competition law, and then public law were quite important themes of my practice.
Okay, and as you have mentioned, you have had the privilege of, up till now, to serve as an acting judge of the SCA for 9 terms. And as you would know, the convention at the SCA is that the most senior judge in any given panel, that is the presider, allocates or designate a member of the panel to write the judgment of the court. And generally, each of the colleagues would write about 2 judgments a term. Are we together?
We are absolutely together, DP.
But what I have observed in your case is that consistently you have been allocated 3 judgments to write per term.
That is correct, DP.
And what would you attribute that to?
Well, I think there are a number of things, DP. The first is that I've found that the work in the SCA has been extremely interesting, and I have, as I was indicating to the Chief Justice, thrown myself into that work. Colleagues on the court appear to have been willing to try me out as a judge writing judgments, and I have I've been fortunate enough to...
Sorry to interrupt you, Judge Unterhalter. If you could try and speak directly to the mic, I'm battling it.
I'm so sorry. Let me come forward. Yes, I've been fortunate enough to have senior colleagues allocate cases to me, and I've also co-written with a number of colleagues on a few occasions, and on 1 or 2 occasions stepped in when a colleague was overburdened as a presider. And so, yes, I've been both fortunate to be given those opportunities, and I hope that the work product has been adequate.
And in the majority of those cases, they were not, the ordinary run-of-the-mill type of case, but those were complex matters which called for resolution of vexed questions of law.
Yes, that's correct. I have found the cases that have come and that I've been lucky enough to write about challenging issues, often complex, and I've had to square up to the issues in the cases, and I have sought to set out my judgments as clearly as I could, and as promptly as I was able to do.
And I've seen that you were born and bred in Johannesburg. The SCA sits permanently in Bloemfontein, Platteland Dorp, extremely cold in winter, extremely hot in summer. Are you prepared for all of that? I'm raising this with you because a story is told more than a century ago of a Chief Justice who hailed from Cape Town and chose to sit most of the time in Cape Town rather than in Bloemfontein.
Well, DP, I know that the following is sometimes said of Bloemfontein, that you cry when you arrive and you cry when you leave. I am happy to have been there in person this year, and I'm happy to serve in Bloemfontein. There are things to appreciate about the city that I didn't know existed. For example, a wonderful planetarium that we were fortunate to visit a few weeks ago.
Thank you, Judge Unterhalter. Thank you, Chief Justice.
Thank you, Minister. You are covered. Okay. Commissioner Nyambi.
Thank you, CJ. Afternoon, Judge.
Good afternoon.
The last time we were here was in April last year for the Constitutional Court. Maybe if you can try to deal with the objection first.
Yes, certainly.
And after the objection, probably try to do some reflection about the interview the last time you were here. Anything that you think you want to bring our attention in terms of correction out of the engagement that we have had with you in your own reflection the last time you were here.
Well, let me deal firstly with the objection, if I may, and I'm happy to take questions thereafter. If there are issues arising from my last interview, I'd be happy to take those questions, which, of course, you should raise if you wish. I'd like to just very, very briefly set out what has happened and place it on record. On the 15th of September 2023, the president of the SCA told me that a Mr. Ashuko had raised an objection to my appointment to the SCA based upon a complaint he had lodged with the Judicial Conduct Committee on the 10th of March 2023. I had not been sent the complaint, and on the 18th of September 2023, the JCC did so. Mr. Ashuko had brought proceedings in the High Court against ABSA and First Rand Bank. I heard the application in 2019 and dismissed it. I refused leave to appeal, as did the Supreme Court of Appeal and the Constitutional Court. Mr. Ashuko's complaint against me is this. On the 16th of February 2023, he received an email from me headed Payment Advise, ADVISE, with an attachment titled Payment Schedule. Mr. Ashuko could not open the attachment, but alleged that the email was evidence that I was receiving bribes as a result of the judgment I'd handed down in favor of the banks. Now, I've provided a full answer to the JCC on the 20th of September 2023, 2 days after receiving the complaint, and the JSC has been provided with my answer. In my answer, I explained the following. Early in the morning on the 16th of February 2023, while serving in the SCA, I received a call from Justice Sachs, the retired judge's secretary. She said that Justice Sachs had received a strange email from me. I replied that I had no knowledge of sending an email to him and requested her to send the email to me. This she did. On opening my inbox, it was evident that Justice Sachs was not alone. A large number of recipients had received the same email headed Payment Advise, ADVISE. Many were returned to me as undeliverable, having been blocked as spam. Others were opened by recipients, some of whom wrote to me to report that my email had been hacked. An examination of my inbox made this clear. Some of the recipients are persons known to me, with whom I correspond. Others are lawyers and judges known to me with whom I do not correspond, and yet others are persons unknown to me. I reported the matter at once to the IT personnel of the SCA, and they in turn did so to the OCJ. It was evident that my emails had been hacked. The email received by Mr. Shuko, save for the identity of the addressee, is in every material respect identical to the email sent from my email address to large numbers of recipients on the 16th of February 2023. Every email is headed Payment Advise, A-D-V-I-S-E. The text is identical, quote, please see attached payment advise, exclamation mark. Please confirm receipt, unquote. And the attachment is headed, quote, payment schedule with the same numbering convention. I pointed out in my answer that I understand the difference between advice and advise. The email received by Mr. Ashuko was neither composed nor sent by me. I've never taken bribes. The email relied upon by Mr. Ashuko is not evidence that I have done so. And the email he received was the result of my emails being hacked. I requested the committee to dismiss the complaint. The committee has not yet heard and decided the complaint, though I've requested that they do so urgently. Mr. Ashuko's complaint is without foundation. Since his objection rests entirely upon the complaint, it must fail for the same reasons that his complaint does. That is what I have to say on the subject of Mr. Ashuko's objection. As to your second question, I stand open to answer any questions you may have arising out of my last interview.
It's not a specific question about anything that I want to refer you, but I was just giving you an opportunity because there were issues in the last interview that were raised then that I was just conversing with you in your own reflection, whether is there anything that you might have said in the last interview that with the hindsight you think you might have put it differently this time around?
I must say that the interview that I had last time is an interview that I don't think was, I must tell you quite candidly, a fair interview. It fastened onto matters, some of which I was taken by surprise and ambushed, which is completely contrary to the criteria of this body, and others became the focus of deliberations which simply failed to engage my record in its totality, and I don't think that that is the manner in which this body is enjoined to conduct itself. I don't think now you can say to me, well, go back over your interview, and is there anything more I should raise concerning it? There were numbers of points raised, and I'm happy, as I say, to answer any points that are still troublesome in any way to you or to the JSE, but I don't think you can come to me and say, please review your interview and have I had second thoughts. I have had thoughts about numbers of matters, and I'm very happy to engage with you if these are still issues of concern to the JSE.
My last part, Judge, well, I must indicate that your technical competence is not even an issue, it's outstanding. And your conceptual understanding of the law, it's something that we marvel at. And your hardworking as it has been reflected by the DP. But you are quite aware that there might be one or two previous cases of other judges about issues that are going to JCC. But I'm happy about the clarification that you have done. So you can assure us that with that clarification, there's nothing unto us that can just take us back if you can be appointed and join the SCA.
Well, I'm very pleased to hear that.
Thank you, Judge Unterhalter. Thank you, CJ.
Thank you. Commissioner Moimang.
Thank you, Chief Justice. Good evening, Judge Unterhalter.
Good afternoon.
Just one question from my side. It relates to the recent judgment that you have also raised, the blind South Africa versus the Minister of Trade and Industry.
Sorry, I'm not hearing. Which judgment are you referencing?
The blind South Africa.
Oh, blind SA, yes, of
the
course.
The blind South Africa
yes.
versus the Minister of Trade and Industry. What is the significance of this judgment as it pertains to the new regime that is being introduced in South Africa in relation to the Copyright Act, particularly its relevance to the disadvantaged society that the judgment was made in their favor. Of course, the other element will be when you're not going beyond what the bench must do, in the sense that by reading Section 13A, one gets a sense that you were legislating from the bench. Thank you.
Well, I must say I consider Blind SA to be one of the more important judgments that I have penned. It concerns, as you rightly say, a constitutional challenge that was brought to the Copyright Act. And it was brought by persons who suffer visual disabilities. And their complaint was this: they said, whilst people who don't have those disabilities can have very wide access to literary works, there is a great scarcity of such works available to people who have these disabilities. And the reason that that is so is that under the Copyright Act, the owners of copyright have to consent for formats to be created that will be suitable for persons with visual disabilities. And they said that was discriminatory and unconstitutional. Now, many people worry about the way in which constitutional rights should engage with questions of intellectual property. But our Constitution, as I was saying earlier, is foundational to all our endeavors, including those that involve intellectual property. And what I found in the case, and what the Constitutional Court found as a whole, was that the way in which the Copyright Act worked and the kinds of rights that were given to copyright owners in respect of literary works and how proper formats could be created for those with visual disabilities was discriminatory, because it directly discriminated on the basis of disability. And the observation that I made in that case, which I think does bear some reflection, is this: that sometimes, in order to treat people equally, you have to treat them differently. And that is precisely how this case came to be decided, which is that we can't simply say that the incidence of certain rights under the Copyright Act are of invariable application by copyright owners. It depends how they affect different classes of persons. And where it has such a plain detrimental effect to those with a particular disability, you sometimes have to do more in order to treat people the same. And that's part of the important jurisprudence around equality, which is a fundamental feature of our constitutional jurisprudence, and this is a contribution to that jurisprudence.
Thank you, Justice Unterhalter. Thank you, Chief Justice.
Thank you. Commissioner Marumohai.
Thank you very much, CJ. Good afternoon, Judge.
Good afternoon.
I want to speak to you about a judgment that you wrote, and you are quite right and spot on it, but I just want to deal with a different aspect from it. The W versus Williams Ashman, the wills and section 2B.
Yes, indeed.
Obviously, the case was dead on arrival, and you you completely dealt with it in a right way. That look, Section 2B is quite clear. If somebody dies within 3 months, then these are the consequences of it, and you do that quite well. But I just want to deal with something that when I read the judgment actually came out, and I started thinking about it. When I read the judgment, the person who wanted to benefit from the will, the ex-spouse,
Yes.
Raised an issue that there may be extraneous sort of circumstances that you should read into in order to find in her favor, right? And I just want to pick your brain on this, that when one looks at the structure of Section 2B, it appears to be, the provision itself, it appears to be a sort of a limitation of freedom of attestation in somehow, because it allows the legislature to say, under these circumstances, we will read the will in this particular way.
Yes.
So with that thinking in line, is there scope to say, but if the parties can bring that extraneous sort of information, the courts can, to some extent, given how the freedom of attestation has already been interfered with thus far, is it possible that under those circumstances there might be some information that might lead courts to decide differently under these circumstances?
Yes, I mean, you've pinpointed a very important feature of both the judgment and the issues that arise from the judgment. But Section 2 has as its purpose this notion, which is that a recently divorced spouse who then dies within 3 months of the divorce is unlikely to have wanted, after a divorce and a settlement and a proprietary resolution of their different affairs, to have wanted to continue to benefit their ex-spouse unless they have plainly provided for it in the will. So Section 2 is an intervention that says we will allow for the possibility that when people divorce, they don't always change their wills, and so this is a protective mechanism. And it is a protective mechanism which is intended to show a kind of fidelity to the testator's will, because they recognize that amidst the turmoil of divorce, you may not, as a divorced spouse, have gotten round to changing your will, which you probably crafted in happier times. So hence the regulatory intervention. What the appellants complained about was that they accepted the regulatory intervention on the part of the legislature, but they said there should be a more expansive basis upon which one could look to extraneous evidence for the purposes of understanding what did the testator really intend. And what I found there is that there isn't warrant in this kind of circumstance to look further than we would ordinarily look for the purposes of interpreting a will, because the intervention is intended to treat the will in a particular way. It treats the ex-spouse as if they had predeceased the testator. And the question is there any reason then to adopt a different principle of interpretation of wills, as we now do in contracts, which is a much more expansive doctrine of interpretation? And I found that there is very, very good policy that lies behind why we read wills in a highly restrictive way, and I continue to apply that basic reasoning even in respect of the statutory presumption, which is a regulatory intervention. But, Professor, you point out an important question, which is, given that there's a regulatory intervention which gives rise to a presumption, not as to how the will actually reads, but how it is taken to read, should we then be more expansive as to what we can look at for the purposes of then thinking about the will? I said no.
No, thank you. With your permission, CJ, can I just follow up? Yeah. No, you are right, because your reasoning is spot on, and you are absolutely right. And I'm asking you in this context, when you look at, I'm not sure if you are familiar with this, Section 37C of the Pension Funds Act, which gives the trustee of a pension fund a discretion to decide how the members' retirement benefits should be distributed. In other words, it completely takes away the freedom of attestation. It throws it out of the window. So I was just thinking along those lines, to to say, are there circumstances where the courts can be open to say, but looking at this, because the legislature has actually guessed what the testator would have done during the course of 3 months before the pass of 3 months.
Yes.
So in that sense, I'm just thinking, isn't there a way or room for the courts to think a little bit more purposively, if you like?
Yes, I'm worried about that approach, because what it starts to allow for is a great deal of extraneous evidence to come in, which is highly self-serving on the part of the surviving ex-spouse, to say all kinds of things as to what the testator actually intended, when the testator, now dead, can't speak for herself, which is precisely what happened in this very unfortunate case. And that's the policy reason behind being quite constrained in this sort of context, which is to say, we assume a recently ex-spouse didn't want to benefit their partner who they've just divorced. And what I think one needs to think very carefully about is, does one really want to encourage a trial where the living ex-spouse now comes along and says, oh, but it was always understood that even though we were going to get divorced, if one or other of us were going to die, you know, we still have fond enough feelings for each other that really I was intended to be. How does one run that trial, practically speaking? And I think that was part of my concern.
Oh, thank you very much. I really enjoyed reading that judgment. And by the way, I was in your competition law class at VET.
Well,
thank you very much.
I'm not sure that was educative, but I hope it was.
Commissioner Dodovu.
Thank you very much, CJ. Good afternoon, Justice Unterhalter.
Good afternoon.
Yes. The matter that I'm going to raise with you pertains to the interview that was held last year in April.
Yes.
In which an issue arose about you presided over a matter at the level of the SCA, and again on the same matter at the level of the Concord.
Yes.
But be rest assured, I'm not going to use it to penalize you.
I'm happy to address it if you would wish.
Yes, I will not apply double jeopardy because I express a view then, and that is water under the bridge. The reason that I'm raising this matter is because such mistakes are not permissible or are not needed, especially at this particular level. We can't afford to make such mistakes where a referee becomes a player or a player becomes a referee. You can't do both things at the same time. Now, what guarantees are you giving that going forward in the future, for the implication of the future perspective, that such mistakes are not going to happen again, especially from you, a person of your caliber and reputation?
Well, let me thank you for the opportunity, because I'm happy to deal with this point. The first is that I don't accept that it was a mistake. And had I not been ambushed at my prior hearing, I would have told you why it wasn't a mistake. It's a contentious question, certainly, but I think that because the nature of the test that is applicable for the purposes of determining leave to appeal to the Supreme Court of Appeal, and the test that is applicable for the purposes of appeal to the Constitutional Court are not the same. And although there are certain common elements, the fundamental overall question is quite distinctive. And therefore, the proposition that was put to me last time is simply not a simple proposition at all as a matter of law, but I don't suppose one really wants to investigate that. But I don't accept in the first place that it was a mistake. The second thing is this, that to the extent that you suppose that I did you seem to elevate that to some very high level of problem. I'm not certain that you fully appreciate the manner in which these two courts work. The volume of cases that come for the purposes of considering whether to give leave to appeal in both these courts. They are many, voluminous, and as was made plain last time, nobody in the whole court, none of the people who assist us in determining these matters by way of clerks and the like, picked up this error. So if it's an error, which I don't accept, but if you say it's an error, it's a collective error that was suffered by everybody. So you must be saying of the Constitutional Court, where the error occurred, if it is an error, that everybody is to blame. So that's the second thing I would say to you. The third thing I would say is that it is not breaching a question of being a player and a referee. It is just being a referee in two contexts. And they are different contexts. So for all of those reasons, I would suggest to you that while I accept that anyone can make an error and everyone will know that that can occur because these are big, complex cases that come and often under conditions of urgency and pressure, but I don't believe that it's an error of the kind that you characterize. But I will say this, that I endeavor in all my work not to make errors if I possibly can, and you can rest assured that I act diligently, and if I have made an error, I will be the first to acknowledge it and seek to repair it as quickly as possible.
CJ, can I just follow up on this?
Yes.
For me, it's quite important. I don't precisely remember all the issues that were ventilated by that time, but my recollection is as follows, is that you acknowledge that you made a mistake, and that's my recollection, and I'm putting it to you, that you acknowledged that you made a mistake and that you should not have, you should have actually recused yourself at the Constitutional Court. That is my recollection on this particular
your
matter.
Recollection
and you saying, no, let me just finish.
Please, of course.
So that, listen to my question first so that you answer me comprehensively. For me, this is quite important. This is extremely important. I want to repeat it, and I'll tell you why I'm repeating. I say to you, my recollection is that you acknowledged that this was a mistake on your part. You should have recused yourself at the level of the Constitutional Court. And you're saying here that you never said it is a mistake, and
No,
going
that's not
forward
what I
in
said.
future, are you responding?
I'm sorry, did you say something, Judge?
Did you say something?
I'm sorry.
You
Please,
are
please
interrupting
complete
me.
your
Yeah,
question.
just wait until the commissioner
Sorry, I
has
thought you
finished.
finished. Please carry on.
Yes, and this is quite problematic, Justice Unterhalter. I'm saying to you that that is my recollection, that you said, I might be wrong. My recollection might totally misplace me. But I'm saying to you that you said this was a mistake. You should have recused yourself at the level of the Concord, given the fact that you checked and you realized that you served at the SCA on the same matter. And now you say you never said that it is a mistake. Now my question to you would be, if my recollection is correct, what posture and what view should I take about you, especially when you've got to be elevated to the SCA? If my recollection and not yours is correct, does it mean that you would have misled this commission or not? Thank you, CJ.
If I may then answer the question that you've posed. Your recollection is absolutely correct, that in the course of the interview, after this matter was raised, not in accordance with the criteria of the Commission, It was done by way of ambush, and it was deliberately done because you may recall that one of your number asked a preliminary question to every single candidate as they came before this body without raising the issue with me in advance of time. So as a matter of what happened, this body took me by surprise, entirely contrary to the criteria that are of application, and that's the first thing. But when it was raised, as it was raised, it seemed to me that there was a basis for the mistake, and I was willing to acknowledge it as such because I had not had time to reflect upon the question, and it's a question of law. So it is not correct, which is your second proposition to me, that I am now saying that I didn't say it was a mistake. I'm saying that now that I've had an opportunity to reflect upon the matter, which is an opportunity I should have been granted last time I was here, I reach a different conclusion as to whether it is a mistake, or to put it at its lowest, it is a far from clear question as to whether it is a mistake as an objective question of law. So that's what I'm saying. I'm saying, having now had the opportunity to reflect on the matter, an opportunity I should have been given and wasn't given last time, I'm not certain that the premise upon which I was questioned was a correct premise. But if it was a correct premise, then I say again that it was a collective mistake that was made by every single judge on the Constitutional Court. And I assume the purpose of your question is not to suggest that the Constitutional Court is made up of judges who shouldn't be sitting in the court because they participated in the same mistake that I made.
CJ, I really beg your indulgence because there are so many issues that I'm picking up, and I don't want to find myself in a situation where I've got to make a decision and I have not garnered all the necessary information.
I will allow you to.
Oh, you do. Thank you very much.
I was going to have a follow-up question myself, so
yes,
let me allow you.
Yes. I must say to you, Justice Unterhalter, with what you are responding to me about, I'm totally now in the dark. I'm more confused than how I was from the beginning. And firstly, let me just emphasize this point. It's an important point. I will not judge you, and I will not use the interview that was held last year to penalize you, to punish you. All that I wanted to know is that such a mistake will not be repeated, because this, where you are applying to, is the second highest court in the land, and people who go there must go through the eye of a needle, if I may put that word. They must be thoroughly scrutinized. We must ascertain ourselves that these are the proper candidates because of the nature and the complexity of the matters that they deal with. This is why I want to be certain, because there's no doubt in me, you are an eminent person. What I see here is a person who can make an immense and immeasurable contribution to the judiciary, to the bench, at that level. I take that particular point. But I've got this particular issue that I want to, that I traverse with you. That is why I'm stuck a bit in this. I'm saying to you, my recollection is that at that point, not now, at that point, you said two things.
Commissioner,
Yes.
remember that he said your recollection is absolutely correct. So
Or
we might
that
not
he
need
made
to
a
repeat
mistake.
it. Yeah. He said your
that is why I say
recollection.
I'm now confused now.
Yeah, he said your recollection of what happened, what he said last time was correct.
Yes, okay,
But
okay.
what he is saying
Yes.
is this, if I can explain, as I understand it, and he is there, he will tell me if I'm misrepresenting him. He is saying, last year, I was asked this question without any notice. He says I was ambushed. And there was a discussion. And at that time, I took the view that there was a mistake. But he says, since then, I've had time to reflect properly and think about the issues that relate to that question, to what happened. I now say it was not a mistake. So I accept that I said it was a mistake then, but there are circumstances under which I said it was a mistake. If you ask me the same question now and say to me, was it a mistake? I'm going to say to you, it was not a mistake. That's what he is saying. Let's allow Commissioner Dodov first because I think he might be asking what you want to ask, if it's a follow-up.
I'm not like you. I have a paralegal training, which is very, very good. But be careful that it is extensive. Yes, it's extensive. Now you saying now this is not a mistake, and if it is, it's a collective mistake by the entire bench of the Concord. Is this the understanding?
Well, what I've said, just to be clear, is that it seems to me that it's actually a difficult question of law. My own view is that it's not a conflict, but I acknowledge that there are others who would take a different view on the point. But the way it was presented to me last time was that I had placed myself in an irretrievably conflictual situation. I don't think that the legal premise is clear. And my own view as a lawyer is that it's not a mistake. But I understand that others can take a different perspective on this as a matter of law. It hasn't been determined by a court of law. And I can also accept, if this will be helpful to you, that because it isn't clear as a matter of law, it is generally wise, I would think, perhaps to step away in the Constitutional Court in these unusual circumstances. But if you want to know where I stand on the question of law, I don't think, as a matter of law, that it is a conflict. But rest assured that if you consider this to be a matter that, in your conception, was a mistake, it would be an issue if I could rerun it again that I would speak to my colleagues about. And if it's a disputed question of law, it may be the more prudent thing to step away. And I accept that that might be the route to take.
Okay, thank you. I'm okay. CJ, thanks.
Thank you. Well, it may well be that one can leave the question there, but I don't remember all the facts, but what is in my mind about what the issue was that you had been involved in the SCA in a matter where you dealt with an application for leave to appeal. I can't remember whether you had granted leave or you had refused leave, but somehow the matter ended up in the Constitutional Court. I seem to think that you probably had refused leave because I think it was an application, well, it might have been an application for leave either way. It was an application for leave in the Constitutional Court as well, and that you had taken part in the decision in adjudicating that application for leave in the Constitutional Court. That's what is in my mind. And that the question that had arisen was whether it was right for you to take part in adjudicating that application for leave in the Constitutional Court in circumstances where you had also taken part in adjudicating the application for leave in the same matter in the Supreme Court of Appeal. Now, my recollection too is similar to Commissioner Dodovu's one, that the final position, as I understand it, was that you said, look, it was a mistake. Maybe you said oversight, it was a mistake. What I do recall also is that arising out of that experience, I suggested that we introduce a new thing at the Constitutional Court, where in regard to each new application that arrives, the judge who prepares a memo and circulates to all the judges to say what his or her recommendations are, that at the top of the memo, all the names of judges who have been involved in the matter at different levels before it comes to the Constitutional Court should be listed, so that it's going to be easy for everybody to see if any one of the Concord justices or acting justices has been involved before. So that's my recollection of what happened and what steps I took to try and make sure that it will be easy to see if somebody has been involved before. Is my recollection correct as well?
Chief Justice, your recollection is absolutely correct.
Yes.
And I did acknowledge, as I've said in answer to the question, that it was a mistake at the time it was raised. I've explained that I think the question as to whether refusing leave in the SCA is dispositive of what the question is to be answered at the Constitutional Court is not the case, but that's a question of law, and it's never been determined in our jurisprudence. And indeed, Chief Justice, you did indeed institute a procedure to make sure that it was known if an acting justice had previously dealt with the matter in the SCA, and that is now a routine part of the papers that come.
Yes. Okay, all right. I don't know whether Commissioner Klaba still has a follow-up.
Well, Chief Justice, my question was going to be crisp.
Yes, please go ahead.
I mean, in the sense that since you have engaged and you left me in the dark as to what your position would be if a similar situation were to arise. The question is, and would you recuse yourself? That's the question, and simple and straightforward.
No, I think it's an important question.
Yes, I think it is an important question, and I think the answer to the question is this, that since the question of law has not been determined, and there are different views as to what the law is on this subject, it would almost certainly be, after discussions with colleagues, the approach to take, which is err on the side of caution and step away from the case as a pragmatic matter. And if that was the view of colleagues, then that is exactly what I would do.
If, for whatever reason, you were to decide, either because of what your colleagues sitting with you in the matter say, or of your own, to participate, would you invite the parties to make submissions on whether you should participate?
I think that might well be prudent. It may simply be, as I've said, a pragmatic answer, which is to say that since one doesn't want to raise questions of law for the purposes of getting on with the business of the court, one could probably simply speak to colleagues and see where they stand on the matter. And if it's a disputed question of law, which is unnecessary to determine, then simply pragmatically step away unless there's some reason why one needs to participate. And if there was some reason to participate, it would probably be useful then to secure the views of the parties.
Of course, this kind of situation if you are at the SCA, it would only arise in respect of a matter in which you were previously involved in the High Court?
Well, I think, Chief Justice, this is a highly unusual circumstance which really only arises because I was in the SCA in one period and relatively shortly thereafter went to act in the Constitutional Court. That sometimes happens and could happen again, but it's that move from being in one court and acting in another that gave rise to the problem, and that's not the most usual circumstance.
You see, part of my earlier concern is that the basis on which the matter had been disposed of during the last interview, for me, made it easy to say, look, this is unlikely to happen because Judge Unterhalter accepts that it was a mistake or it was oversight. So it's not going to easily happen. But where somebody says, no, it's not a mistake, you get worried that if a similar situation happens, he might then sit because he doesn't see anything wrong. So you start thinking about that. But I think the answer you have given, that you think it would be prudent, irrespective of whether legally it's correct or not, it would be prudent not to participate, and that if you were to participate, probably you would look at inviting the parties to make submissions about whether you should participate or not. Probably that might assist in making sure that the matter would be dealt with transparently.
Indeed, Chief Justice, I completely agree. What this illustrates is that if the issue had arisen, it would be a matter for discussion with colleagues, as these matters often and generally are, and one would be guided by what colleagues have to say on the subject. And quite naturally, if there is a sense that there's no point in resolving a disputed question of law when my participation is not needed for the purposes of deciding the case, well then, of course, pragmatically and sensibly, that is what I would do, and the matter would rest there.
Thank you. Commissioner Nochesi, and then I've got Commissioner Traba.
I just wanted to make a follow-up.
Who is speaking? Oh, virtual platform. I've recorded
Commissioner
you.
Malema.
Commissioner Malema, you want to follow up? Please go ahead.
Just a quick one. The question is not about what are the views of your colleagues if the matter was to repeat itself. What is your conscious view as we stand now, before you get canvassed by different colleagues if the matter was to repeat itself? We want to know where you stand now, not what you are going to do. Because before you go to the colleagues, you've got your own clear conscience position of wanting to participate or not wanting to participate and being persuaded otherwise by colleagues. Having discussed this now and in the past, where do you stand now? Not what colleagues colleagues say when the matter arises in the future. That's what we want to understand. Thanks.
Well, I hope I've been very clear. My view as a matter of law is that it didn't give rise to a conflict of interest, but I'm aware of the fact, having thought about it quite carefully, that other judges and lawyers could take a different view, and that is why I would most certainly consult with my colleagues. And the fact is that in courts, that's precisely what collegiality requires. And I would listen to what they said. And if I was ultimately persuaded that my legal view is wrong, I would obviously change. But I would also be persuaded, as I've indicated, that if there's no need in the light of a disputed legal question to sit, I would pragmatically step aside.
Thank you. Commissioner. Thank you. Commissioner Klaba, do you still have a question?
Yes, no, it was a follow-up.
It was a follow-up, okay.
Chief Justice.
Commissioner Marumohai. I'm sorry, no Jesse.
Thank you, Chief Justice, and good afternoon, Judge.
Good afternoon.
In fact, intended not to ask any question from you. But because of this debate, and unfortunately, I'm the one who asked you this question last time.
Yes.
And there's something which discomforts me.
Please speak up, Commissioner.
Yeah, there is something which discomforts me, because you gave an answer. This is the record. This is what you gave. You said at that time to the question, because the question that was asked was purely a procedural question, whether a judge who had sit over a matter in the SCA could sit over that matter when when is in the CC. And this was your answer. If it is an appeal from the SCA, the answer would, I think, be not, unless there is some distinctive feature of the case. But no, I think the answer would standly be no. That's the answer you gave. Then, if you were ambushing anyway, it could have been the production of the actual order. But the question itself, it cannot be an ambush. It's just a procedural question. Now, I'm worried about the answer now that you give compared to this one, because my understanding was that you would simply acknowledge that, look, because this is the answer that you gave to at that time. My expectation was that, look, it was a mistake based on the things that you talk about, the volumes of cases that are coming and everything. But it seems to me now you take it further to say, well, because there is a different test that is applied, and then there would be legal argument about it. And that's where my discomfort is. If you can just...
Well, I've explained this position now probably 4 times over, and I can explain it again. I acknowledge, and I've acknowledged at least 3 times, that that the position that I took at the last hearing was the one to acknowledge that it was a mistake. I have had occasion to reflect on the matter. I think it rests on a quite difficult question of law which has never been resolved, and therefore my own view, and it may be wrong, is that I don't think it was a mistake. But I could be wrong, and as I've acknowledged, because it could be a disputed point of law, I would consult with colleagues, and I've given my answers. I'm not certain I'm not rowing back from what I said last time. I am saying that the premise of the question that you posed was that it was a mistake, and that's why you thought I should not have sat. And I'm saying that the legal premise is not correct. But I don't think I can there's nothing more I can say on this score.
I understand now. I think we could leave it here. I understand your position.
Thank you. The last one on my list is Commissioner Marumohai.
Thank you very much, CJ. Judge Unterhalter, I thought when the issue was raised, you would say, look, it was unfortunate, and we leave it there, and we proceed with the interview. But your answer now concerns me. You are quite right. It is a legal issue. But I'll take it further. In fact, I think it is a constitutional issue in this sense. When somebody applies to the Supreme Court of Appeal, and you are one of the judges who are allocated to deal with the matter, the impression that as a litigant I have is those 2 judges will consider my papers, they will read my papers quite carefully, and they will apply their minds on my papers and then make a decision. And usually when the Supreme Court of Appeal dismisses the matter, they don't give reasons, right? Without a hearing, of course, they won't give reasons. Now, I get an order that says my application has been dismissed, And I'm like, okay, I don't agree with what the judges are saying. I don't know why they dismissed the application, but you take it like, okay, I think they have erred. Then I go to the higher court. And when I go there, one of the things that I put on my papers is those two judges erred. So, I'm going there because I'm expecting different judges to look at the matter. And now the impression that I have is I go to the higher court. Those judges at the higher court will be different judges who will look at the matter. And one will think that if there is a judge who was at the lower court at the time when I brought the matter there, and that judge is confronted with the same papers, if this judge really looked at my application, there would be something, a paragraph or something, where the judge can say, but I might have seen this. But let's say that there was an error and the judge did not, because it's possible, we are all human. The provision that I'm putting is, the difficulty, herein lies the difficulty, that I'm expecting different judges to look at this thing, but only to find out that one of the judges who had already pronounced on the matter is on this panel. And I think that's where the difficulty is. And when the Chief Justice asks you whether, if the matter can arise, will there be a possibility of asking the parties to make representations, that also is problematic. One would think that, look, I've done the matter, I take myself out. I think had we left it there, it would really have assisted. But that's just my concern. Thank you.
Well, if I may very briefly respond. The expectations of litigants is one thing, but what is the law is another. The matter that is being considered by the Constitutional Court for the purposes of deciding whether to grant leave to appeal is not the same matter as what is being considered by the Supreme Court of Appeal. The test is different and the considerations are different. And I've, in some sense, sought to elucidate some of that in a recent judgment. So, whilst I understand the perspective that you bring as to what might be the expectations of litigants, the question at the end of the day is whether the matter is the same. And the proposition that I have put is that the matter is not the same, and consequently the conflict doesn't arise. But I've accepted entirely that lawyers can take different positions on this proposition, and I could be wrong. But at the end of the day, one has to have a view as to what the law is, and that's my view. And I can be persuaded that I'm wrong, and if I was persuaded, or if it was pragmatically relevant to simply avoid having to deal with the legal point at all, I've explained what I would be.
Thank you, Judge. Thank you, CJ.
Well, I know that we want to finish, but I have a feeling that it would not be right for this to be left just at this. What I'm talking about is, you have been saying to us, legally, it's not clear that if a judge sat in an application for leave to appeal at the Supreme Court of Appeal, and subsequently an application for leave to appeal is made by one of the parties in the same matter to the Constitutional Court, you say it's not clear that legally the judge who sat in the same matter in the SCA should not sit in the Constitutional Court. That on the face of it sounds quite strange to me. I hear that now you are saying it's not the same issue. But the fact of the matter is, it would be, you have two parties who have a dispute against each other. This dispute might have different issues, but it's the same dispute. They take it to the High Court, they take it to the Supreme Court of Appeal, they take it to the Constitutional Court. They want to resolve this dispute between them, but the one court might use one issue to resolve it, another court might resolve another issue, but these are all issues in the same dispute. How can it be that legally a judge who has sat in the SCA and adjudicated an application for leave to appeal in that dispute can also possibly sit in the Constitutional Court and adjudicate one or other issue in the same dispute.
Chief Justice,
Chief Justice.
Sorry, there's some feedback.
Chief Justice, sorry.
Sorry.
I thought before the judge responds, because I'm going to be just following up on your question.
Oh, Commissioner Singh.
Yes.
Yeah.
Yeah, so then he can give one response to it.
Yes.
Because thank you, Chief Justice. Chief Justice, I'm quite confused, I'm not a lawyer, but for me, it's just common sense. One cannot be a player and a referee at the same time. And in this case, as you quite rightly said, Chief Justice, the matter was the same. It was leave to appeal, and leave to appeal was refused where Judge Unterhalter sat in that matter. And when the matter came to the Constitutional Court, he sat in the matter without recusing himself. Now, one would think that that was wrong from a common sense point of view. And for me, it's not law, but it's just common sense that one has to recuse themselves if they've been part of an earlier decision. That's all I want to say on this matter. Thank you, Chief Justice.
Thank you. Just to go back to my question, I was saying, Judge Unterhalter.
Chief Justice.
Commissioner Malema.
Yes. I was in the same spirit saying, before he responds, perhaps I should also add something on that one, because he says the legal issues and expectations of the litigants are two different things. But my question would have been, as a follow-up, adding to what you asked, what is his appreciation of justice must not only be done, but must be seen to be done? You appear from a person who rejects your leave of appeal, you go to a higher court, and then he says the law is not clear about that. I sit on the same matter. What happens to the principle of justice being seen to be done? Will I see justice being done in the context of him sitting on this matter, rejecting the appeal, and then going to sit on a higher court to listen to the same matters? That's what I wanted to add to your question. Thanks.
Thank you. I know there are different questions now, Judge Unterhalter. You'll tell me if it's confusing. But I had started off by simply saying, I understand you to be saying when you sit in the Constitutional Court, it's a different issue. It's not the same as the issue you dealt with in the Supreme Court of Appeal. But I was saying the dispute might be the same, but it has different issues. So you are sitting, if you sit in the Constitutional Court, having sat in the Supreme Court of Appeal, it would seem to me that you are sitting in the same matter. The fact that in the SCA, the issue was different, it was the same dispute. That would be my approach. Why do you think one can sit, nevertheless, just because it's a different issue in the same dispute?
Well, from my perspective, the question isn't whether it's the same dispute. It is the same dispute. The question is, what is the test for leave to appeal? The test is distinctive. The considerations are distinctive. And therefore, the issue is whether, in coming to a conclusion as to leave to appeal in the SCA, has one preempted and, as it were, pre-decided the question as to what is the test and what is the application of that test in the Constitutional Court. It's different, and therefore I don't see the conflict. But I understand that this is a somewhat rarefied question of law about which reasonable lawyers, and clearly, Chief Justice, you and I, and with complete deference to you, I understand that there is a different view of the law on this subject. I hold a different view. I may be wrong, and it's precisely because I recognize that my view of the law may be wrong that I would obviously consult about it and would take whatever is the pragmatic approach in order to avoid an issue which is unnecessary.
One of the issues that both the Supreme Court of Appeal and the Constitutional Court would look at when these two courts consider an application for leave to appeal is prospects of success. And prospects of success means looking at the merits. what the chances are that the applicant for leave to appeal will succeed if leave is granted. So that particular issue, if you sat in the Constitutional Court, you would be looking at it for the second time, isn't it?
Well, it depends. It all depends, because the question in the Constitutional Court is whether there is a legal question or a constitutional issue, that whether there's a legal question of public importance to be resolved, or there is a constitutional issue. Now, I accept that there could be circumstances in which that was the issue before the SCA, in which event there would be a coincidence of issue, and therefore one would be conflicted out in that circumstance. But it's not the case that that is true in every single case. So, for example, if the question is the interests of justice, that is a consideration relevant to the Constitutional Court, but the SCA has said it is not a consideration relevant to the SCA.
Of course, the SCA has got constitutional jurisdiction and can consider constitutional issues as well, which may end up going to the Supreme Court of Appeal, and it can consider questions of law which can end up in the Constitutional Court as well. We all know that.
They can be.
Yeah.
I'm not for a moment suggesting that there are not circumstances in which it could be the same issue, in which event there could be a conflict and it might warrant recusal. I'm saying, though, that it is not an inevitable feature because the tests for leave to appeal are distinctive, and hence the issues relevant for determination can and sometimes are distinctive.
Yes, thank you very much. Commissioner Malema asked the question, asked you to comment on the dictum that justice must not only be done, but must be seen to be done, whether if now in the Constitutional Court you were to sit and adjudicate the application for leave to appeal, which you adjudicated in the Supreme Court of Appeal, whether how that would affect the perception of justice in terms of people saying, is this justice? He wanted to hear what you have to say about that.
Well, the test for recusal is very well understood as to what a litigant might reasonably understand on the basis of the correct fact and a correct appreciation of the law. And there are two principles that apply. You can't recuse yourself generally simply because a litigant feels that you should go. You have to apply the law of your recusal. And I'm saying that the law of recusal here would be responsive to what is the issue and what is the relevant test of application in the two courts. And only once one had appreciated those questions could you concretely determine whether there was a conflict and whether there was a perception on a reasonable basis with a proper appreciation of law and fact as to whether recusal is required. Recall, if I may, Chief Justice, because
Yes.
we've been having a very lengthy discussion about this matter, that the way this was put to me when I was last here was, it's an obvious conflict. You were clearly mistaken, and you had to recuse yourself, and it's a grave error that you made. That's what was put to me when I was last here.
I think there was another commissioner who had a follow-up, who put a follow-up earlier on, but probably you have answered it because I don't see an indication. I think if it's possible, I would like Justice Betzer to be the last one on this.
No, Chief Justice, I do want also to have a voice, but
okay.
Not necessarily being the last.
No.
I'm happy to defer to Justice Betzer as the last. But
I was saying on this, otherwise I've got you on my list.
Yes, no, I do have something on this point.
On this one as well,
but I'll defer to seniority.
Yeah, okay.
Thank you, Chief Justice. Judge Unterhalter, I just want to come from a different angle. On the same facts, you considered an application for leave to appeal in the SCA, you refuse it. Would it then be appropriate if the same litigant were to bring a Section 17(2)(f) application for reconsideration of your refusal to consider the reconsideration?
No, it wouldn't be, because there it's the same issue then arises for consideration. So there you couldn't sit twice.
Thank you. Thank you, Chief Justice.
Thank you. Commissioner Marumuahai, I've got you here, but I think
I'm covered.
You are covered.
Yes.
Thank you. Thank you. Then it's Commissioner Ngugaitobi.
Yes, thank you, Chief Justice. Justice Unterhalter, you know, when I was a junior, I used to watch you argue cases with a lot of skill and a lot of admiration on my part. And it struck me in the course of listening to you today on this point that one of the skills I enjoyed specifically was that you didn't give up on a point. And and you know, David, Justice Unterhalter, you know, the thing was that even when a point initially appeared hopeless, you argued it, and in the High Court, and you ultimately prevailed in the Constitutional Court. We asked for a record of the JSC deliberations in the High Court. The point was hopeless. Everybody said the point is hopeless. But, you know, we won 11-0 at the Constitutional Court. But it just struck me now that actually you were playing the role of advocate, but today you are trying to get a job at the Supreme Court of Appeal as a judge. And maybe there is scope for concessions here and there because it's a different position that you're trying to get to. So in that spirit then, I just want to just remind the actual facts of what happened on the last occasion, because I've now gone through the actual transcript, and I think there has been a conflation of two things, not intentional. I think everyone is acting bona fide. What you considered was an error is that you were not factually aware that you had sat in the SCA when you sat in the Constitutional Court.
Correct.
That's what you said twice was an error. What you didn't concede was that it was a legal wrong. So today you've been arguing that it was not a legal wrong. But there's no problem in making the legal concession without, on the facts, going back. Because on the facts you said it was an error because I had not been aware. That is what today you are saying was a collective error. It's the lack of factual appreciation that you had said in both. That is what fell through the cracks.
Indeed.
So in the light of that, I mean, because there's actually perfectly reconcilable factual premises here in terms of what you said then and what you said here. And I felt uncomfortable when Commissioner Dodova was saying, have you misled the forum, this body? That's why I actually went to see what did you say, which is different. I don't see exactly what the differences are. So I would just like to encourage you not to argue the point and for us to move on from the point. I think that the general view is that whether you are right or not, this is not going to be decided by the Constitutional Court. You are no longer Advocate Unterhalter, you are Justice Unterhalter.
Yes, I thank you for that intervention.
Yes.
I accept entirely that I didn't appreciate at the time that I sat on the matter in the Constitutional Court that I had sat on it in the SCF. I just simply didn't recognize that that was the case, and I said so last time, and I say so again. And nobody else on the Constitutional Court recognized it either, and in that sense I say it was a collective failure. What the legal position is in circumstances where this does happen, because of the lack of appreciation of the fact that I had sat previously, is a disputed question of law, and I've had everything I could possibly want to say on that score.
I think it's enough to say it's a disputed question of law. I think what I wanted to resolve was the factual issue of what happened, and I think we are together there. Chief Justice, I do have a legal question to pose to the candidate.
Please go ahead.
Yes, thank you. The judgment you wrote, the minority judgment in ESCOM.
Yes.
Yes. Would you regard that as a hard case in the Dawkinian sense, in the sense that there would have been two permissible outcomes. Because the way you've described it in your application is that the majority adopted a consequentialist approach.
Yes.
And you, by contrast, examined the substantive content of the right. And if the claim of the applicant couldn't be located in the substantive content of the right, the consequences, hard as they may be, and that's the hard case according to Ronald Dawkins, we had to live with those. Now, there is a lot to be said about the majority's approach in the context in which South Africa finds itself, and the anxiety in which the courts feel disempowered. Why should we not intervene when we can see so much suffering and so much misery, which we can resolve by a piece of paper? So I do want to just look at whether that judgment is a reflection of your philosophy and how you would approach similar hard cases in the future. Because on the one version, the Dawkinsian approach is devoid of principle, or maybe not principle, maybe legal principle, but it's devoid of empathy, you know.
Yeah. Yeah.
And that could be a point to be raised. But on the other hand, you say, well, in order for the law to keep its credibility, it has to reside ultimately on legal principle. And that's where Dawkins actually is important as a teacher. So is that a reflection of your philosophy? And one of the things I don't understand with is why you had to go through all of that. It's hundreds of pages, but it was an interim interdict application. So I wonder whether if we had a full application on disputed clear rights issues, whether or maybe your perspective would have changed in that case, or because maybe that's what should have happened. Instead of the matter being decided on very difficult philosophical questions of law on an interim basis, it should have simply been left to the final judgment.
Yes, well, I'm glad that the ESCOM case has come up, because I think of all the cases that I've written about, that was the case that is a truly, truly hard case. And it's a truly hard case because the reduction in the supply of electricity to that community was giving rise to very, very considerable hardship and indeed probably immiseration of people who were very vulnerable. So it's incredibly difficult when you get a case of that kind to say, well, surely that's the moment to just intervene and provide a remedy, perhaps an interim remedy, to try and alleviate the immediate harm. And that's why it's a hard case. And the majority of the Constitutional Court said, in effect, we look at the harm and we determine the right by reference to the harm. Now, I think, and three other justices of the court agreed with me on this point, which is this, that, and there are two, I think, points, and the one is a point really around the division of powers. Too often, the courts are being asked to resolve problems that under our constitutional order are actually the constitutional responsibility of other organs of state. And in this case, what is highlighted is that it's the municipality, as the Constitutional Court has previously held, that has the responsibility for dealing with those very conditions. And the risk of displacement, which is to say, courts should decide and resolve every hard consequence of what happens through various species of government failure, is a temptation that I think one needs to be very, very careful about. So I'd firstly raise the question around separation of powers. But the second, and maybe this does reflect my judicial philosophy, is this, that the key feature of our Bill of Rights is that one has to understand what they say, what their content is, because it's so important to the work that those rights have got to do, and what they do not say. And one has to work out what is a litigant claiming and what is a litigant not claiming. And it seemed to me, and it seemed to those who agreed with me, that that is the correct starting point as lawyers, and what courts must do is not simply say, I have to intervene because the consequences are harsh, unless the test involves a consideration of consequences. I must start with where is the right? And if that's considered to be too loyally a view, I don't think it is, because the liberating aspects of our Constitution must both begin with an understanding of what the rights are about, but they must also appreciate what courts can do and what they can't do. And that's, I suppose, why the ESCOM case is important and why it is somewhat reflective of my philosophy.
Just one more point, Chief Justice. I think, I get your point that, you've got to look at the text first and try and locate the right in the text. Now that I see, but I wonder whether, because when you look at the majority, it's sort of derivative, right? It's not direct, there's no right to electricity, right? But electricity implicates a number of other rights, right? Dignity, health, education, etc. And so what they do is a derivative exercise. And I wonder whether, in fact, there is a distinction in the approach, right, in principle versus consequentialism, in the approach of the minority and majority. And I wonder whether we needed this in an interim interdict application or whether it should have just been kicked for later.
It may well have been the pragmatic answer to say, let's all come back against the fuller facts and resolve these ultimate questions of right. But it did seem that an answer needed to be given because it has had systemic consequences for the country as a whole. If, as the majority found, the municipality in this instance was permitted simply to avoid its constitutional duty, and ESCOM would be required to supply irrespective of whether there were any rights to assert, it has a massive impact both upon ESCOM and about what happens across the country. So I think that was part of what went into the consideration of this as an interim interdict. As to the question of the derivative right, I agree that it's a significant part of how to think about this problem. But the difficulty I had with that notion was this, that particularly when one is talking about positive rights, as we know, they feature in the Bill of Rights on the basis of what is reasonably required of the state. And so to dictate the means is seemingly a preemption of what the state is given the liberty to determine for itself. And I thought that that was problematic in at least the derivative components of the case that were raised.
Thank you. That was the last commissioner on my list.
I had raised my hand.
Oh, I'm sorry. You did raise your hand. I didn't put it, write it down. Go ahead.
Good evening, Judge.
Good evening.
Just to say that on that very last point you made, I acted in the High Court in Pretoria just after that judgment came out. And I think I was faced with two interdicts around cutting electricity. And I was obliged to say that, well, ESCOM must supply the electricity. And I did fear what your judgment, I think, had anticipated was a terrible opening of a floodgate. And I did wonder how ESCOM can possibly hold up if the court is intervening to tell it on a fairly arbitrary basis where it cannot load shed or cannot cut off supply. So I experienced the difficulty in the court. Yes. But I really wanted to come back to the substantial contributions that you've made to the development of our law, which the reports we get from the law bodies are unanimous. I don't think anyone really disputes that. But I want to focus on two. The one is really procedural, and I think it's the judgment you might have been referring to in the previous debate. I think it's TKW
yes.
Agriculture, where you did start to distinguish on behalf of the SCA the difference between the jurisdiction, the appellate I, for one, welcomed that judgment at a very pragmatic level. And that's because it has created a far greater level of certainty to those of us in practice, and I think for the higher courts, as to when an interim order may be appealed to the SCA. And I wanted your comment on that, that being a procedural case. And then just a question on development of law at a substantive level. We've asked previous candidates about how we infuse contract law with constitutional values. You have written quite a consequential judgment in that regard in the SCA, the Capitec Coral Lagoon. And I'd like you to talk specifically about that judgment, but also in a little bit more detail as to how in a country like South Africa, with some of the most terrible inequalities in the world, we deal with Pacta sunt servanda and at the same time infuse the law with our constitutional values.
Yes, well, if I may take those questions in sequence. Firstly, on the question of Eskom and its consequences, one of the other significant features, which certainly figured large in my consideration of that case, is that there is a very, very detailed regulatory structure which governs Eskom and gives rights of recourse to parties, including the parties who came to seek interim relief. And one should be very, very careful about disregarding what Parliament has set up as a regulatory structure for the determination of the obligations that Eskom has. Again, it seems to me on separation of powers questions, one should be very, very cautious about saying on a consequentialist form of reasoning, well, we'll just accept that Eskom has to do certain things, even though Parliament has created a very, very significant regulatory system, which includes the opportunity to raise the very kinds of issues that the applicants did in that case. So I just raise that as another point, which is why the consequences of the Eskom judgment are ultimately ones which burden Eskom in ways where an entity that is in the public interest of everybody to be an effective provider of electricity is set upon with huge problems. And the question is, did we make it better or worse? In my own view, we made it worse. And I don't think that's something a court should lightly do. But there's another view, and I accept that. The second, if I may, on the question of the standard of appeal, I went to some lengths in that judgment in the appeal court to explain something else which I think is extremely important about the Constitution and the way in which we adopt standards, which is that the rule of law requires that there should be clarity as to a matter as important as whether you can come to the Supreme Court of Appeal on appeal. And I voiced the concern that both high courts and litigants were simply taking their chances in every single kind of case to bring their cases to the SCA, and that what really counted, at least in the SCA, was the issue of finality and the tripartite consideration under Zweni. I made special reference, however, that if there is a hierarchy of consideration here, the High Court must, generally speaking, finalize the cases before them. If they are finalized and there's a point worthy of consideration on appeal, they can come to the SCA. And what the role of the Constitutional Court is not to become a court of general appeal, but to pick carefully, as it does, those cases that specially require the apex court to give consideration to the matter. It's not the court that you go to as in every single case. And that's why I've sought to make clear what the relationships are between these three levels of courts, what are the kinds of comity issues that should be respected as between those courts, and why the Constitutional Court is special and should be given a very wide scope within which to pick what it spends its very precious resources on determining, and that's the effect of that case. Lastly, in respect of Capitec and the question of how does one infuse, as is so often said, the values of the Constitution into the common law, I think that is so easily said, but concretely, how you do it is very, very much more problematic. You may think this is a degree of radicalism beyond what is warranted, but the notion of small incrementalism is actually not what the Constitution says. The Constitution doesn't say you can enjoy your rights in slow increments. It says so in limited circumstances in respect of positive rights. It says if those rights are rights that matter for the development of the common law, you have a right to it immediately, not in some future world. That was the conception often at common law, where the notion was often said, well, we're not quite ready for this development. And so courts, for example, on questions of pure economic loss said that for decades and decades and decades until somebody finally said, well, now the moment has arrived. Quite why that was the moment was never explained, but suddenly the moment had arrived. Well, that's not what a constitutional state is about. So I think one needs to give a systematic account of what the constitutional foundations of the law of contract are. Now, I know frequent reference is made to Justice Froneman's minority opinion in the Baedeker case. I think there are very enormously complicated questions that arise from it because it works on a principle of fairness in exchange. And fairness in exchange has two components to it. The one is, what is the fairness as to the power of the contracting parties? And what is the fairness as to the distributive outcomes that such bargaining brings about? They're not the same problem, they're different problems, and I somewhat fear that Justice Froneman underestimates that they should not be thought of in the same way. But if you ask me the question as to whether not just in this country, but in many, many countries, that one doesn't want to develop a doctrine around how parties can engage in contracts without regard to the relationships of power that exist as between them, I would say there is a doctrine that requires some liberation. The existing law of contract already holds many of these principles as part of what it does. What the law of misrepresentation is about is partly about exploiting power which you're not entitled to in the context of contracting. And one can say the same of mistake and a variety of other doctrines in the law of contract. But the question is, against the principle, where do you go further? And my own view is that it shouldn't simply be consigned to this notion of public policy, which has just become a tag for not actually explicating the really important questions about what is a constitutional theory of contract. And that's my view about that point.
But what is the constitutional view of contract?
Thank you.
Sorry, Chief Justice, I apologize.
We have kept this candidate very long. It's 7:30.
No, Chief Justice, I withdraw.
Okay, all right. I think we have come to the end of this interview, Judge Unterhalter. Once again, thank you very much for availing yourself for the interview. We appreciate it. You are now excused.
Thank you very much.
Thank you.